Ladies and gentlemen, I'm Iman. Before we begin the show, you must be wondering about meetings. What is it? Well, for starters, meetings are when a group of people, usually two or more, come together. Why? Well, they meet to discuss on a matter in order for them to make a decision together. So, who holds these meetings? Based on our show, which leans more towards the formal setting, companies commonly have a variety of meetings that includes their board of directors, shareholders, and members. But in general, the casual meetings are held by everyone from staff members to teachers at school. Even our group had a meeting for this show, an informal one. In order to conduct these formal meetings, we must refer and abide to all the provisions provided in the Companies Act 2016. Without further ado, let's begin the show. To define a meeting, we must refer to the classic case of Sharp versus Dawes. This case officially defines meeting as a coming together of more than one person. There must at least be two people. However, under the Companies Act 2016, mitigating circumstances allows a meeting to be held by one member, which is an artificial meeting. For all sole member companies, that sole member can either pass a written resolution or provide the decision's details to the company. This decision will then be equal to the company's decision if agreed by all the members in a meeting. Subsequently, the corporation, that is the sole member, may then be represented by its corporate representative, who is entitled to exercise their powers as corporate shareholder. And if one person holds all the shares of a particular class, that person can hold a meeting for that class.
Thank you, Iman. Amir here. On this episode, I'm going to show you the 5 types of meetings. Firstly, there's 4 meetings are held as shareholders or members meetings. Other than that, others meetings are also held, which includes the board of directors meetings. Starting off with shareholders or members meetings, the first meeting that we are going to discuss is statutory meeting, which enables members to know all important matters regarding the formation of the company, as it is held once in a company's lifetime. Information regarding shares taken up, money received, contracts entered, and sums are discussed here. Every public company that is limited by shares must hold this meeting within a period of not less than 1 month and not more than 3 months following the date on which the business is entitled comments. In order to converse this meeting, a notice of at least 21 days prior to the meeting should be given to the members. A statutory report by the board of directors should be sent to every member 7 days prior to this meeting. Next up, an annual general meeting (AGM) is a yearly gathering between the shareholders of a company and its board of directors. Only a public company is required to hold an AGM. The business conducted in AGM involves the laying of audited financial statement and the reports of the directors and auditors. Besides that, the election of director to replace the retiree ones alongside to appoint and fix the fees of directors. Lastly, AGM includes any resolution or other business of which notice is given in accordance with the Companies Act 2016 or the Constitution. What are the requirements to hold an AGM? The first requirement is a public company's first AGM must be held within 18 months after its incorporation. For the subsequent AGM, it must be held every calendar year, but not later than 6 months from the end of the company's financial year. On the other hand, if a company is not able to hold its AGM within prescribed time due to any special circumstances, the company can apply to the Register of Companies (ROC) for an extension of time. What are the consequences for non-compliance of these requirements? If a company fails to hold its AGM within prescribed time by the Act and the ROC, by default, every officer of the company shall be held guilty of an offence against the Act. Next, the Haikal also meant on the application of any member order a general meeting to be called. Continuing to matters of who can call an AGM, standardly, the Board of Directors convenes the AGM through passing Directors' resolution, or a member apply to the court for an order to call for an AGM. Pursuing this further, there are two importance of AGM, which are to comply with the statutory imposition to hold such meeting, as well to fulfill the company's contractual obligation to its member through an opportunity to meet and query the directors regarding the company and exercise their right to vote on any resolution, directors' election or auditors' appointment.
Thank you, Amir. I'm Haikal and the show must go on. Moving on, class meeting is a meeting of shareholders where the only attendants are those that hold a particular class of shares. Usually this meeting is called in the event of proposition to vary the rights of class of shares. This is where the members discuss the pros and cons of the proposal and vote accordingly. On top of that, the meetings are held to pass a resolution where only the members of a related class can attend and vote. A company's constitution will set on how the meeting is conducted alongside the consent requirements. Following up, we will now look into the extraordinary general meetings. As explained by Amir, we know that the companies are legally required to run their annual general meeting once per year. However, what if an unusual occasion happens? What if there is a sudden vacancy in the director's position in result by the disqualification by the board or death? This unexpected situation requires quick and effective resolution. That is where the EGM comes in clutch. All special and urgent cases that absolutely cannot be delayed until the next annual general meeting will be discussed in the EGM. The EGM can be conducted 2 months after the requisition notice, and if the directors didn't convene it between 21 days, the meeting can be held by the requester themselves. This meeting must be for the purpose of the company and within the power of the general meeting. And finally, is the Board of Directors meeting. The aim of this meeting is to preserve the smooth managing of the company and make collective decisions. In this meeting, the directors will discuss on matters such as fund investment, money funding, issuing debentures, call on shares, and what measures should be taken for the best interests of the company.
Thanks to Haikal. Hi everyone, I'm Ruben. On this episode, I will talk about convened meeting, or in simple terms, arranging a meeting. It is essential that meetings are convened properly to be considered valid, as well as to avoid resolution passed from becoming void. The first thing that you need to know is that these are the 4 parties that can be convened meetings. Let's begin. Let's see for the first convened meeting by Board of Directors as stated in Section 310 of Company Act 2016. They do so by passing a director's resolution. This means that the directors themselves or on the requisition of members may convene any shareholders meeting to vote on certain issues that require the agreement by the members. Next, moving on to convened meeting by members. A meeting of members may be convened by any members holding at least 10% of the issued share capital of a company or lower percentage depending on the constitution. Alternatively, if the company has no share capital, meeting convened can be done by at least 5% in the number of the members. Meanwhile, convened meeting can also be done by members holding 10% of paid-up capital. These members all may require or claim the directors to call an EGM. Following that, when members request it, the director convenes a meeting based on the meeting. Any member possessing at least 10% of the company's issued share capital or members with at least 5% voting rights can summon a meeting of the directors under Section 311 of the Company Act 2016. The directors also have a duty to act when members who meet the membership qualification seek it, which includes convene a meeting within 14 days of receiving the requisition and holding the meeting within 28 days of the receiving the notice to the convene the meeting. The last meeting is one that the court has convened if it is impractical to call the meeting to be held. A court meeting is a meeting or series of a meeting of system shareholders called by the court for the purpose of considering and, if necessary, approving the scheme. For example, a meeting may be called when two directors and two shareholders cannot agree on a topic, or when members are intentionally missing from the meeting, preventing management decision from being.
A case that represents the proper way to convene a meeting by members is Eka Noodles versus Nur Hayati Tukiman. The defendant, holding over 10% of the company shares, issued a notice to request for a general meeting under Section 311 that states members of a company may require the directors to convene an EGM. The court rejected Eka Noodles' argument that the word members refers to plural members. Therefore, even as the only member issuing the notice, the defendant's request to convene a meeting is valid. Click here for the full case.
Now, these are the necessary pre-requirements to conduct a valid meeting under the Companies Act 2016. Starting off with the first, notice of meeting. We will get to this on the next episode. Secondly, agenda gives guidance and information as to the business to be discussed at a meeting. Third is chairman, who is the one that regulates and supervises all the proper conduct of a meeting. Fourth, resolution, which is a formal decision taken by means of a vote. Fifth is venue, aka the location of the meeting. Sixth, proxy, who is the personal representative of a member at a meeting. Seventh, quorum, the minimum number of attendees to conduct a meeting. Eighth, voting, which is the decision at the meeting that is taken by way of passing a resolution. Now, last but not least, minutes. This is the recorded documentation that is used to inform the attendees and non-attendees of what was discussed at the meeting.
The best case to represent an invalid meeting due to not meeting period requirement is Lim Hien Pin v Tien Seng Ko Sendirian Berhad and ours. In this case, the plaintiff's proxy was excluded from voting at the company's AGM, which was not a mere irregularity. Therefore, the court held the meeting void and null as the proxy was prevented from exercising his statutory rights. Hence, the meeting became invalid as it did not meet pre-requirements. Click here for the full case.
Now, let's look into notice of meeting. There is the question of what a notice of meeting is and why we need to know about it. Because a notice of meeting notifies a company shareholders, directors, or other interest parties of a corporate meeting's time, date, and location. This paper can be attached to a meeting's minute and used as a proof that proper notice was given to these individuals. Furthermore, a meeting is still valid under Section 316 even if the corporation accidentally left out the notice to a person. There are a few things to think about while writing a meeting notice. The method is the first component. Section 390 states that notice of meeting of members must be in writing and sent to a member in either hard copy or electronic form or a hybrid of both. How to give this notice? Following either the Constitution or procedures in Company Act. Furthermore, the meeting notice must be posted in the website from the date of notification until the meeting's conclusion. In electronic form, it is via email, and for hard copy, they must be sent personally to the member. Moving on to the next component, period, which is defined in Section 316 as a number of days given depend on the type of meeting and matters to vote. Essentially, at least 21 days notice must be given for a meeting of a public company other than a meeting for the passing of a special resolution shall be called by notice in the case of an annual general meeting. For a private or public company, calling an EGM must at least provide 14 days notice. This notice can be a longer period depending on the constitution. Thank you.
Sometimes, not every meeting requires all the members to be present. On some occasion, a member might not need to attend the meeting. Hence, the notice of the meeting must cover all the relevant information so that the member can decide whether to attend it or not. The contents of the notice must include details such as venue, type of meeting, day and date, what the meeting is all about, and purpose and content of resolution of the special resolution, if any is proposed. And last but not least is the special notice. Some special cases, such as the removal of directors under Section 206 Clause 3 and removal of auditor under Section 277, requires the presence of special notice. The special notice should be delivered at least 28 days before the meeting date. Now, we will look into the most suitable case, that is Safari Alliance Sdn Berhad versus Tiger Synergy Berhad. In this case, the latter competing general meeting scheduled by the Tiger Synergies clash with the initial meeting called by the stakeholder Safari Alliance containing their resolutions. Therefore, the court held that the Tiger Synergies notice of general meeting is null and void. Click here for the full case.
That is it for our show. By now, it is clear that meetings are necessary for a company to discuss and make the most optimum decisions together. Besides, always ensure to convene your meetings properly to prevent them and its resolutions from becoming void. Next, be wary to fulfill all of your meeting's pre-requirements in accordance with the Companies Act 2016 to conduct a valid meeting. On top of that, always provide your members with a sufficient notice of meeting to allow them to prepare and make better decisions. Finally, meetings are held so that a company can operate more systematically and efficiently for the betterment of themselves, the board of directors, the shareholders, the members, and all the stakeholders. That is all from us. Thank you for watching, and we hope you enjoyed our show.